Well, good evening. Welcome to Chapter 6. This is going to be an interesting chapter, I think, for many of you. We're going to be looking at some of the law governing the use of force. We've had a lot of demonstrations, a lot of problems in the United States in regards to the use of force by both civilians and by the police. And we'll look at some of the legal foundation for how the situation was created and how it's dealt with by the courts. So again, as typical, there are these learning objectives, and many of these will give you an overview of what we're going to accomplish, but they're not critical for you to know, again, but I think they're a good thing for you to take a quick look at. Okay, so skipping through those, let's talk about self-defense. Self-defense is when one person is faced with an immediate physical threat, he is allowed under the law to exercise proportional force in response. Now there's going to be a few questions about whether it's justified or not. We'll talk about some of the reasons why you can use force as a private individual. So what reasons do we allow? Well, is the other party, the other person or persons, using or threatening to use unlawful force themselves? And notice that terminology there, because if we're talking about someone who has the lawful right to use force, a police officer in many situations, or an individual defending himself, you do not have self-defense rights, or as full rights, we'll say. The use of force is necessary and the amount of force is reasonable. I prefer the term proportional. So if someone is coming to slap you, you don't have the right to shoot them. That's not a proportional response. Now, I'm not saying that if he throws one punch, you can throw one punch back. If he shoots one bullet, you can shoot one bullet back. It's not as simple as that when you say proportionality. We also ask whether there is a justification, or as your book said, is it justified, looking at what kind of force you use, who's using it, and what are the circumstances. And I think that's the most critical thing that's leading up to this use of force. Okay, so we can look at, this is a model penal code coming up here, section 3.04, and it basically, when we talk about a model code, just a brief aside here, model codes are created by typically the American Bar Association or a legal association with input from others very often. And their purpose is to try to create a uniformity of approach towards issues. So in the civil side, you'll see something called the Uniform Commercial Code, the UCC. That's based upon a model that was created. The model penal code is very similar. So this is one that many lawyers would recognize, many states would use part of, and North Carolina has its own particular rules. But section 304 of the model penal code says, force can be used in self-protection, quote, when the actor, the person using force, believes that such force is immediately necessary. So one of the things about the use of force is the immediacy. For the purposes of protecting himself against the use of unlawful force by such other persons on the present occasion. So we're not looking forward there either. So let's talk about the big one, one that's in the news quite a bit, self-defense. If you're claiming self-defense, if you're saying, I exercised force in self-defense, we're going to look at a couple of things here. Well, actually, we're going to look at three according to your text. But is the other person's actions unlawful? So if I'm trying to restrain you as a police officer and you're using force, that's not self-defense. If, however, I'm just a citizen and I grab you on the street without cause or reason, now that's an unlawful action on my behalf, and you have the right to use force. The necessity to defend oneself. Do you have to use force at this point? And this goes a little bit to the proportionality I'm talking about. How much force? the reasonableness of the act of self-defense under the circumstances. So we're going to look at the circumstances, and we're going to say, like, okay, what force were you faced with? Was it immediate? Was it a serious threat to you? Self-defense is a well-established legal concept. Typically, there was a duty to retreat, where if before using particularly deadly force, if you could retreat safely, you were required to. Now, because of a number of laws, typically called stand your ground laws, and North Carolina has gone down this road, most of that is gone. Besides self-defense, there is defense of others. So if you are coming to the defense of your friend John, we'll look at what's the unlawfulness of the action towards the other. If a police officer was going to arrest John and you intervened, you do not have defense of others. The necessity to defend others and the reasonableness of it. Now, what's often said under the law is that when you go to defend someone, you step into their shoes. So let me give you a scenario. You are at a bar and you get up and you go to the bathroom. And while you're in the bathroom, your friend, John Doe gets into a fight, and he is the aggressor against another person. And he throws a punch and hits the other person first. Now, you don't see this, but you come out of the bathroom, and you see your friend get hit by the other party who is acting in self-defense. And being a friend, you come and protect your buddy, John Doe, by throwing a punch yourself. Do you have defense? And the answer is no. You've stepped into the shoes of your friend. He didn't have the right to use self-defense. Therefore, you will not get the right of defense of others. Okay, Good Samaritan laws. Many states have Good Samaritan laws that encourage but don't require people to get involved. The Maryland statute says, quote, any person witnessing a violent assault upon another person may lawfully aid the person being assaulted in assisting that person's defense. This is Article, I guess, 27, Section 12A. Under these statutes, a person may use force to protect another only if the threat of violence is imminent. The big thing here is it reduces civil liability. However, North Carolina has some laws somewhat similar to this, but wouldn't directly apply. So the general rule is if you're going to defend someone, you are as responsible for their actions as they are. Now, as we move from mere force to deadly force, the rules start to change. So what do we mean by deadly force? Do we just mean if you shoot a gun? And the answer there is no. Deadly force is more than just shooting a gun. Deadly force is any force that is capable of causing death or serious bodily injury. Now, I will say this. Sometimes under the law you see the term per se. Per se is a condition that comes before a statement in the law, which essentially means automatic. The firing of a weapon, the shooting of a gun, is per se deadly force. If you are pulling a trigger, you are using deadly force. And it is not a defense to say, I was shooting him in the foot, I was shooting him in the arm, I was shooting in the air. It doesn't matter. It's deadly force. So you better have a very good reason for using deadly force. It's very similar to non-deadly force. All people may use deadly force, but only to prevent immediate or imminent death or great bodily harm. And it's got to be necessary. Now, as I said, North Carolina used to have a duty to retreat. Now we've essentially become a stand-your-own-ground state where you don't have to retreat. Florida was the first, I believe, and some of these came out of different events that happened. And the stand your own ground says a person who is not engaged in unlawful activity and who is attacked has the right to stand his or her ground. And Florida passed this law a few years back, and more than half the states have embraced it. The statistical evidence is not great about this, and it is somewhat debatable, but at least to my satisfaction, it can be shown that this has led to an increase in the number of deaths. So yes, you can have this law, but you will have more people getting killed because of it. It does encourage confrontation, and it does not encourage the prevention of violence. Some states have gone to make my day laws, and that, for example, it comes from the movie Dirty Harry. North Carolina doesn't tend to use make my day. We tend to typically, if you're looking at North Carolina case law, you'll run across a term called the Castle Doctrine, which is pretty similar. But essentially, make my day laws remove the limits on deadly force to an intruder if someone is coming in somebody else's house. So, example, in the case of State versus Anderson, the court interpreted the Oklahoma statute, which is Title 21, Section 1289.25, as intended to remove the requirement that the force must be reasonable. So an occupant who reasonably believes the intruder has wrongfully entered the residence, intends to use some force, however slight, is privileged to use any force, including deadly force. So an example here, I suppose, in Oklahoma would be if you broke into someone's house, the person was unarmed, but was, let's suppose he was, I don't know, going to steal something or slap somebody. You would be allowed to use deadly force. Now, North Carolina, as I said, has the Castle Doctrine, which is pretty similar, although typically it was used to terminate entry more than it was used to once you're in. And you didn't remove complete proportionality. Okay, so that's what North Carolina calls the Castle Doctrine. It has long been the law that if you're assaulted in your homes by a trespasser, there was no duty to retreat or flee. Because, and this comes from the idea that your home is your castle. It is your possession. You do not, even in states that have the duty to retreat, have to retreat in your home if you're faced with force. You may use force. So basically what it comes down to is, once you're in your house and someone is there unlawfully, and there is a threat or problem, you have much greater leeway in using force. Okay, you can take a look at this Huffington Post article. It's an interesting article about, to simplify it, a man hears some loud music. There begins to be an altercation about it. This is at like a Fast Fair or Piggly Wiggly or something I recall. And it winds up him shooting somebody. And the article really says, you know, does race play an example in such cases? What information would you need to say this was or was not a legitimate use of force? But again, Florida Stand Your Own Ground makes this murder, this killing, because it's not a murder necessarily, makes this killing much more difficult to prosecute. Okay, battered women. Every year, between 500 and 750 women kill men who have abused them. And this begins to raise all sorts of issues about basically issues about gender. Given the fact that women are often placed in subordinate positions culturally, and certainly historically it's been true, even if many of the legal disabilities have been removed from them. There is a physical disparity that exists between men and women, and they often can feel that the best thing they can do is strike back against the person who are abusing them, and sometimes this leads to death. And the question is, should there be a charge of murder or homicide or assault. And as it stands, much of this is a discretionary issue for the district attorney. It's more a defense that is raised. So it's certainly not a, as we're going to see in a minute, it's certainly not a complete defense. So battered women will usually, they can be charged with anything from first-degree murder in North Carolina to voluntary manslaughter or involuntary manslaughter, though probably not that, to assault, to assault inflicting serious injury in North Carolina, to a simple assault. So it really runs the gauntlet. They must fear deadly force, imminent death, or great bodily harm. And the reason it's often not self-defense is they frequently are not in a situation where it's immediate. So the kind of most famous example of this comes, I believe the name of the book was The Burning Bed, where a woman who was being abused by her husband or boyfriend was very badly beaten. One night when he came home, he was drunk, he beat her very severely. He went to bed and passed out. Now, she could not defend herself while he was awake. So what she did was she poured an accelerant, I believe it was gasoline or kerosene or something, on the bed and lit it on fire. And then she was charged because it was not an immediate threat. So typically the battered woman defense has the problem that you can't justify self-defense for attacks that occurred in the past. Now, because there's obviously a degree of sympathy for this, and particularly in front of a jury or something, very often this is called an imperfect self-defense. So you raise it and you say, look, first-degree murder really requires a premeditation and an action. This is something less than that, and you can get a murder charge, if the woman is accused of murder, reduced from an intentional, say a first-degree murder charge, a premeditated first-degree murder charge, to something that carries a much more lenient penalty, such as one of the manslaughters, voluntary manslaughter typically. This is Barbara Sheehan. She might have been the one, actually. After 25 years of life with abused husband, who was also a former police officer, Barbara Sheehan shot him 11 times, it's not her actually, with her husband's gun, killing him. At her trial, she contended she was fear of her life when she shot her husband. She introduced evidence of past abuse. It didn't excuse, but it was relevant. She was acquitted of the murder charge, but she was convicted of illegal use of gun. So, you know, sometimes, particularly in front of a jury, you can get a sympathetic jury. Judges tend to not be as sympathetic, but they're human beings as well. Often, it's convincing the prosecution to change the charge, because remember, most cases don't go to trial. Most cases wind up where the party pleads to something that's agreed upon. Okay, so this next discussion question, where a 33-year-old wife is charged with murder after shooting her husband with a shotgun. She testified that he abused her physically and sexually. She also testified it went off accidentally. Now, if it went off accidentally, she was threatening with him, it can change things. So what facts are important? Are you going to say that the battered, let's suppose she can prove the batteries that occurred in the past, sexual attacks, physical attacks. If you can show that she was using the shotgun to defend herself and it went off, what do you think she might be convicted of? I mean, if we look at the big charges, first-degree murder, second-degree murder, voluntary manslaughter, involuntary manslaughter. You know, do you want to convict her of one of those? Do you want to convict her of, like the previous one, illegally using a gun? We have a charge in North Carolina, assault with a deadly weapon. We have one assault with a deadly weapon inflicting serious injury as well to make it more serious. So you could conceivably charge one of those. All right, let's talk about defense of property. Now, I like to tell my students that, remember, you only have one life, but you can always go out and buy more stuff. You are allowed to use a level of force to defend your property, but that level of force cannot, in most cases, be deadly. Force may only be used when you need it to stop the interference. You can use non-deadly force to stop someone from entering your property or remaining on your property. But I want to emphasize, you can't use deadly force. So you might pull a gun if someone's on your property. Suppose someone's walking across your property and you don't like it. You might pull a gun. Probably not a wise idea, but okay, you pull the gun. Can you pull the trigger and say, well, he was trespassing? And the answer there is no, you can't. If you pull the trigger, it's going to be a charge of murder because you can't use that deadly force. All right, now we get to some of the contentious issues. The first one here is going to be use of force in making an arrest. The first thing to remember is, unless a police officer has probable cause, that would be for arrest, or an articulable suspicion, that would be for a stop and frisk, they are essentially, in the eyes of the law, private citizens. They can't, just because it's a Wednesday, they can't take out a billy club and hit somebody, any more than you and I could. When they are making an arrest, they have to make the arrest based upon the existence of a warrant or probable cause. So, in most arrests, the use of force is unnecessary because people comply and they don't offer resistance. The question is, what happens when someone resists or tries to escape? What can the officer do? Well, the officer is allowed to use reasonable force to detain and make an arrest and conduct searches. He also can overcome any resistance from the offender. He can prevent an escape. He can retake the person. He also has the right to protect himself, to protect others, and even protect the prisoner if necessary. Matter of fact, he's got to protect the prisoner. So once it gets triggered, so let's just stick with arrest. Remember, arrest is based on a warrant or probable cause the officer has independent of the warrant. But let's suppose that Officer John Doe has a warrant to arrest Fred. And Fred is guilty of a crime. We're writing a bad check. And he has an arrest warrant for him. He has the right to detain him, arrest him, and search him. If Fred objects, he can be compelled into custody, physically compelled. He can prevent Fred from escaping, and he can recapture him. Now, what starts to be a problem is when this escalates from mere force to deadly force. When can he use deadly force? Well, you can't use deadly force as a police officer unless you have a reasonable belief that the person you're arresting presents an immediate or imminent risk of death or bodily harm to a police officer or others. So, someone steals a purse. They're running away. They're young, they're fast, you're old, you're slow. You're a cop. Can you shoot them? And the answer is no. However, if an individual has a gun, or if that individual has committed a crime of murder or one that causes serious bodily injury, like a rape or an assault, a serious assault, not just a simple assault like a slap or a punch, then yes, deadly force can be used. The big important case here is the Supreme Court case of Tennessee versus Garner. Prior to Tennessee versus Garner, and this came down in the 1980s, police officers were free to use deadly force to stop anybody who was running away if they were a fleeing felon. Today, you cannot use deadly force to prevent the escape of a person who has just committed a misdemeanor. Did they just shoplift? Did they just steal a purse? Did they just slap someone, punch someone, kick someone? Those are all misdemeanors. If the only way you can catch them and they're running away is to shoot them, and remember, shooting is per se deadly force, you can't do it. Deadly force can only be used where there is an immediate threat to public safety, so says the Supreme Court. All right, let's take a look at one where in Philadelphia, the police reportedly used excessive force. This is a CBS station in 2012 broadcast this, and the question is, does it appear the police in the video used excessive force in arresting the teenager? What would you ask? I mean, I think what you've got to know in this situation is, did the teenager, well, what level of force was used to arrest? Was it deadly force? It wasn't deadly force, okay? Was it reasonable? Was it proportional? What information do you want to know? What did the teenager do? Was the teenager a danger to others? Based on the information and the article, would you say that there's guilt of excessive force? Why or why not? All right, let's talk about DUI. DUI is very, very, very common crime. All states make it illegal to drive under the influence. And they require that anybody that is caught driving in an erratic manner submit to a breathalyzer, blood test, or urinalysis when there is reasonable grounds to believe. Now, in reality, this can be a little difficult. So, what do you do if you pull someone over and you say, I want you to blow, and the guy says, no. I want you to give me a urine sample. The guy says, no. Well, probably your last alternative is to get a blood sample. And again, if he's going to object, you're going to have to use force to remove part of his body, his blood. So courts have typically upheld the right of the police to remove blood samples, even without warrants. However, it does open up significant issues of liability here. If I was a police officer, I would be hesitant to use force to obtain a blood sample unless I was very sure that I was going to find a high alcohol level. Okay, so what can you do? Well, you can use force to try to get them give you a urine sample or a blood sample. You got to have reasonable cause to believe they violated the law, and you have to have a reasonable means. You can use handcuffs, and you can use reasonable force. Now we come to chokeholds. This is something that's being fought over right now. Can you use chokeholds? First of all, if they're used, they have to be limited. The people who use them have to be trained to use them. I would not be at all surprised in the next few years to see them outlawed. They don't seem to be working too well. They do seem to be leading to a lot of deaths. What about tasers? Tasers were argued during their introduction that they were going to give the police another step on this continuum of force. So before they would take their gun, now they can use the taser. It hasn't worked out that way. There was a big study out of Australia not too long ago where they showed that shootings didn't go down, other force didn't go down, they just deployed the taser more often. You may use a taser, but only again if it's going to reasonably aid you in an arrest or investigation. All right, what about children? Okay. Parents have something called parental authority. A parent who has lawful custody may use reasonable force for disciplinary purposes. Now notice all the caveats in there. First of all, reasonable force. You can't typically beat them with objects. You can't inflict permanent injury in any case. You can't cut the skin. You can't do any of those things. All states have laws requiring school officials, health professionals, and law enforcement officers to report suspected abuse. So it's a requirement that if a teacher or a nurse or a police officer saw a child that had the typical wounds you see. Now, children fall down all the time. And if you think about yourselves when you were younger and you fell, most of your injuries are going to be on your elbows, your knees, your buttocks maybe a little bit. But there'll be some places that will be very rare for you to be injured. On the other hand, if you're being beaten, one of the first things you're going to do, for example, is you're going to throw your arms up in front of your face. So if a police officer was to see a pattern of beating on the outside of the arms, where someone would have been shielding themselves from a beating, that's an indication. Many states have forbidden corporal punishment. North Carolina hasn't completely. It's restricted. You do have the right to use corporal punishment in schools. It's not done very often. Again, there are significant restrictions. In none of these circumstances, I want to emphasize this, whether it's a parent, a teacher, a cop, you can't use force just because you want to. If father comes home and he's had a bad day and he just decides Junior needs a smacking, and he doesn't even hit Junior with an object, he doesn't break a leg or cut his skin, and he hits Junior, he doesn't own Junior. That's still an assault, and Dad is still chargeable there. Okay, on that rather sad note, sorry to see, we will conclude this chapter. We're moving along. We're getting ready to move into, just shortly, into some of the exciting chapters. We're going to start looking at the homicides and the assaults and the sexual assaults. We're just about out of covering all of the kind of foundational work so you can understand what we're doing overall. All right. Have a good night, everybody.